Good evening and a very welcome to continuation of our company law class. So yesterday we were still at the introductory part, and among other things, we explored the question where the rules that constitute company law in Ghana are derived from. We also examine what should be the proper role, what should be the function of company law in an economy. Now tonight we will quickly continue with the introductory part and hope to quickly finish so that the way will be paved for us to start discussion of a substantive topics. So in terms of where we are regarding the historical evolution of a company law in Ghana, it is important to note that the story of how we develop our company law is very much linked with the historical development of company law in England and Wales. So in England and Wales, before we came to have what we call like the modern company, right? The modern incorporated company around the mid 19th century. There have been various ways of organizing business. We have the merchants, marauders, imperialists, speculators, who use all manner of schemes and strategies to get various advantages for themselves in the world of business. And some of them became so powerful that they could create cartels. They could create powerful, like to use economic language, monopolistic organization for various unfair competition or advantage, as the case may be. But there had been certain forms of organizing business which existed in the ancient Greece and Rome, and those forms of organizing business had been with the people of the medieval age until we had the introduction of the modern company, as it were. So if you go back to ancient Rome, for example, Italian states, we had what we call the commander, which had the equivalent in Arabic, Kirad or Isaac in the Jewish tradition. And the idea of the commander was that investors will entrust capital or merchandise, that is goods for sale, to agent manager to trade with and return the principal plus agreed share of practice of profits. So the remaining profit will go to the agent, and he or she bore no liability for partial or total loss. So that was how the commander was. I mean, that's a way of organizing business in those days. And you notice that we could say the commander, in the way that we have explained, combined elements of loan, that is giving a loan, and also partnership. But you could not treat it as really a loan arrangement. Neither could you treat it as partnership, as understood later on under partnership law. But it was still a means of spreading risk and allowing investors to spare cash, that is monies that they have no immediate use, to put them into business without running it. So the agents will run the business for you, so to speak, and then they'll take part of the profit. Now, in the 13th century, the canon law lawyers from the Roman world developed a very important legal concept of incorporation, which we call the persona ficta, that is the juristic or artificial person, to address the defect of absence of entity in commander as a vehicle of business or investment. Now, if you see the commander, there was nothing like an entity that is a structure which stood on its own, which was, for example, could be seen as the business, so to speak. That was lacking. But the canon lawyers introduced a concept, the possibility of having a legal person separate from, let's say, a natural person, so to speak. And that is what will eventually develop into what we call the separate legal personality later on in England and Wales. But it is important to remember that those of you who are familiar with a little bit of European history, when various trade prospered or flourished in England, in Italy, various city-states, we have the artisans or craftsmen who organize themselves into guilds. So the guilds are like association of people with similar traits, and so maybe those in the leather industry do for themselves, or those who make shoes, or those who make various textiles, to form themselves into guilds to pressure monopoly of particular traits, and also to regulate members who carried business in that particular trade or industry. But the idea of the guild was not really to create any form of corporate trading association, just to regulate and control the way people who were in a certain industry, for example, did their work for the good of all members of that particular industry. Now, international trade, that is the practice of trading beyond your national frontiers with others, became very popular because there was a practice of giving a charter. When we say a charter, let's say that the monarch, the British monarch at the time, be it the king or the queen, will give a charter. A charter is like a royal mandate, authority. Just like in these days, the universities are giving charter. You take your Presbyterian University, for example, not too long ago, it was chartered, meaning that it has come full scale of development and it can stand on its own. So similarly, in those days, the monarch will give you a charter and say that you will be given the authority or the mandate to take charge of all trading, let's say, around the Indian Oceans, or trading in the Africa, or trading in this region where the British are able to establish their colonial empire and so on. But that also had a certain problem because that was the beginning of, if you like, formalization of a major monopoly. Once you be given the charter, then you were in charge of a whole stretch of geographical area as far as certain trading was concerned. That notwithstanding, we could say that it was probably a better way of doing business than the commander. Since in commander, the business could collapse, and in terms of maybe people involved dying, issues of reorganizations of the business will become a matter of concern. We are just giving you a very sketchy outline of some of the very initial historical background of how we got the present day incorporated company. So that is the purpose of what we are doing presently. So this evolved what we call like the joint stock business, where resources were pooled in a common enterprise. So a joint stock company typically created a permanent fund from shares in the stock of the company invested by the capitalists and managed by a select body drawn from members or board of directors. Now, when the members died, their shares could be sold to a new member. So that was, if you like, a very neat way of organizing business. Bring money, B will bring money, C will bring money, D will bring money, you will bring money. And then we reduce the money into certain way of counting and said, okay, if you brought 10 cedis, we could say that you probably have 10 shares. If you brought 20 cedis, we could say that you have 20 shares, and so on and so forth. So that gave us an idea of how much stake each of the capital contributors, if you like, had in the business. And they will select a small number who had the time, the interest, and the competences in terms of management to manage the business. So those who were selected to manage the business will be called like the board of directors. Now, those who had contributed the capital, like they are what in modern time we call them the shareholders. Now, when members of the joint stock company died, their shares could be sold to a new member. So that was one of the beauties of the joint stock arrangement. But an important aspect of the joint stock company was what we call perpetual succession. That is the possibility of the business remaining in perpetuity. That is to say that the business will not collapse or die with the death of, let's say, the members or the people who were in charge of it. So the business had what we call it the perpetual succession. And that idea ultimately will be traced to the canon law lawyers' concept of the personal factor or the juristic person. So the way of contributing capital in the joint stock is what will develop into what we call shares or stocks. So now when you hear of stocks, it's the same as shares. And for that matter, as far back as the 1671 case of Salomon against a Hamboro company, it will underscore the ability to make calls on members to pay the company's debts. That is to say that that case recognized that, okay, if you had shares, then what it meant was that if the company entered into losses or debts, you could be called upon to come and contribute towards payment of those shares, of those debts, because you were a shareholder. And of course, that will be proportion to the shares that you have. So in the Salmon's case, for example, the House of Lords made an order to the Chancellor to levy assessment on members of the joint stock company to pay for the liability sued for and costs. So pay attention to this. These members contributed capital, right? And we say that they have shares. Now the court is saying that, okay, if the joint stock business is owing, then we are going to split the debts among the members who contributed towards that joint stock company. Now, in 1720, that is the early part of 18th century, there was an interesting but the worrying development. There had been massive or exponential growth of public markets. So there have been booms and slumps. And that brought about the passage of what we call like the Bubble Act. And what do you mean by that? What happened was that people who were now using the joint stock company idea could entice others to put their money in the joint stock company and create the heightened hope that they stand to get so much profit and so on. But there was not proper regulation in terms of how the affairs of the business was managed. And despite the massive patronage of maybe people putting their money in the joint stock company and all that, due to absence of adequate regulation, it actually led to unfortunate development of businesses collapsing and people losing their investment and all that. And it was in the wake of that legislation called the Bubbles Act was passed to regulate the joint stock companies. And it established what we call the Royal Exchange and Landing Assurance Corporation and forbade the formation of any joint stock companies unless approved by a royal charter. And then it's also sought to protect the South Sea Company, a company which will be given the permission to trade in the South Sea area. Now, there was an interesting development, and that development was that now, following the passage of the Bubbles Act of 1720, if you wanted to set up, any company, you needed to get what we call the royal charter, or you needed a parliament, to pass a particular legislation, as it were. But all that did not help, and there were further abuses. And because of the abuses, there was an inquiry which was set up. There was an inquiry which was set up, that is a committee, to look into the state of affairs regarding businesses, joint stock businesses, and various businesses enjoying royal charter. And their reports exposed various abuses and fraud which was being perpetrated through those existing arrangements. And they made a recommendation that instead of having a very scattered arrangement of bringing about companies, and what were those arrangements? Like, you have to get the parliament to pass a specific legislation, or you have to get the king to give you a royal charter before a certain business company will have come into existence. They said that it was necessary to have a dedicated legislation, one legislation which will provide a framework for acquiring the business vehicle, which we call company. So that led to the passage of what we call the Joint Stock Companies Act of 1844. Joint Stock Companies Act of 1844. And it was this Joint Act Company of 1844 which gave birth to the first form of registered company. So mind you, we are not saying that before the Joint Stock Companies Act of 1844, there were no companies. There were companies, but how they came into being was through you getting a royal approval, like a royal charter, or getting parliament to pass a particular legislation which will incorporate your business, so to speak. But we did not have like a general legislation for incorporation, like, for example, our current Companies Act 2019, Act 992, in which you can just comply with the provisions and you get your incorporated company status, as it were. But the Joint Stock Companies Act of 1844 actually paved way for that. So let's keep that in mind. So under the Joint Stock Companies Act of 1844, companies could be incorporated by registration if the company had more than 25 members. So in those days, once you got 25 members, you could go through the registration procedures, and then you will be able to get a registered company. It also created the Office of the Registrar of Companies, and this Registrar of Companies was supposed to be the body responsible for receiving or collecting various particulars of registered companies, as it were. Then it further provided for registration of deed of settlement of companies. That is the constitutive documents of companies, the principal constitutional documents, and in return for status that is recognized by law as entities in their own right. So once you have submitted your constitution, once you have complied with the other requirements for registration, and all the right boxes are tick or check as having been complied with, you are given recognition that yes, you exist in law as an entity in itself. So you acquire the separate legal personality status, and you have perpetual succession, and so on and so forth. It is pertinent to note that despite the creation of the registered company, the 1844 Act, that is the Joint Stock Companies Act of 1844, did not confer on the membership of these companies limited liability. In other words, if you were a member of a joint stock company registered pursuant to this 1844 Act, you did not have limited liability. And what do you mean by that? That is to say that if the company incurred debts, you could be called upon to pay those debts so long as they had not fully been paid for. And that was quite worrying. In that case, there's no difference between you and a sole proprietor. That is a one-man business, someone doing a business by himself or herself. Because if you're doing a business by yourself as a sole proprietor, if you make losses, we can even get your personal assets sold in satisfaction of the debt that you owe people. So if you were a member of a joint stock company and you could be called upon to pay the debts of the company without any limitation, then how different were you from the sole proprietorship? Probably the only difference would be that in the case of sole proprietorship, if the sole proprietor dies, the business has died. So there's no perpetual succession. But for the joint stock companies, if the members dies, because it is a legal person in its own right, it will continue to exist and had that element of perpetual succession. So after almost a decade of operating the Joint Stock Companies Act of 1844, there was the Limited Liability Act of 1855, which was passed to supplement the original legislation. So under the Limited Liability Act of 1855, it allowed companies with at least 25 members, each holding shares to the minimum value of £10 with at least 1/5 fully paid up on the share, to incorporate with a limited liability status. So now there's a progress. We are moving forward. So the 1855 legislation said, okay, if you have 25 people who have registered as members and each has paid a certain minimum amount, let's say like £10, and 25% of the shares, that is 1/5, is fully no, that's 20%, not 1/5, 20%, isn't it? Yeah. That is fully paid, then you'll be allowed to enjoy what we call the limited liability status. And what is the meaning of the limited liability status? Limited liability status simply means that where the company has incurred debts and the company, for example, is winding up or is liquidated the liabilities, You as a shareholder, you as a member of a company with limited liability status, you cannot be called upon to pay more than the amount of shares which you hold in the company regarding the debt. So after paying the value of the shares which you have, even if the debt of the company still remains, nobody can ask you to make further contribution. In other words, all that you stand to lose as a shareholder in a limited liability company is the amount of money that you're supposed to pay on your shares. So you lose that one and you not get it. But beyond that, even if it is not enough to pay for the debts of the company, nobody can ask you to come and make any additional payment. And this is different from where there's no limited liability. If there's no limited liability, then it doesn't matter that you are a shareholder, you are paid for your shares, you will be called upon to come and contribute towards payment of the debt of the company until it is fully paid off. But if you look at the report of the commission, which culminated in the passage of the Limited Liability Act of 1855, there had been significant concern as to whether it was worthwhile to allow companies to enjoy this limited liability status, because there was the fear that some companies may exploit the public in the sense that they would let people put their money in the company, get shares, and they will use the company to be taking various debts and all that, and people thinking that the company is capitalized, and in the end, it will turn out to be something else, and people's money will have been wasted. So that was one major concern. And before we move on, I'll give you a practical illustration. When I was a lawyer some time ago, we did a case against the Ghana Veneer and Plywood Company. There was some Ghanaians living in the US who had supplied some equipment to them, and they were owing them at almost $200,000 to $300,000. Now, we got a judgment all right, but when we got the judgment, we could not execute the judgment because the Ghana Veneer and Plywood Company was more or less a moribund. It was not operational, despite the fact that if you go to the Registrar General's Department, you still see it in the records. There was no assets or nothing. Now, when we did search at the Registrar General Department, we got to know that the Forestry Commission was 100% shareholder of Ghana Plywood and Veneer Company. And we know Forestry Commission has got various properties and all that. So one would have thought that, oh, then you are lucky, why not go and attach some of their properties in the execution of the judgment? No, that could not be done because of the company law principle we call the separate legal personality and so on. Because the Ghana Plywood Veneer Company is seen as having a legal, having a separate legal personality from the shareholders, the Forestry Commission, as it were. Yeah, so that is the story of how we came to have the limited liability concept. But we'll come back and engage this again as we get to the substantive topics. So, with the passage of the 1855 Act, what it came to is that if you needed to get the status of a joint stock company or incorporated company, so to speak, you needed to register your constitutional documents. And in those days, they were Two, what they call memorandum of association and articles of association. Unlike the joint stock in those days where they used to have what they call like the deed of settlement, like the deed of agreement. But now this had been reduced into two documents. Memorandum of association, which is supposed to be the major constitutional document setting up the various organs of the company. And then the articles of association, which also give like the detailed rules regarding operations of the company. And later on, when you read the case of what do you call like the Tech One case, for example, an issue will come up as whether outsiders who are dealing with the company should be deemed to know the internal working procedures of the company or they shouldn't. Especially so when those documents are registered with the registrar of companies. Now, the various restrictions which the 1855 Act had introduced regarding what needed to be done before a company will be allowed to enjoy limited liability status, such as the fact that you should have about 3/4 of the nominal capital subscribed actually paid up and all that. That was not workable. So, that was not workable. So just about a year later, the law was amended to remove the restriction relating to the minimum amount of capital to be contributed by members of a company. And again, it also reduced the minimum number of members required for purpose of incorporation from 25 to 7 members. So now, if you want to register a company, you don't need to get as many as 25. You needed to get 7 members. In 1862, all the scattered amendments following the passage of the original 1844 Joint Stock Companies Act were brought together into one legislation, what you call consolidating legislation. So that was the Companies Act of 1862. And of course, you know the Industrial Revolution in Britain, that period in which businesses, factories, and all that were doing very well. So various businesses took advantage of the new law to get the business vehicle we called incorporated or registered company to do their business. And that also provided impetus for the law which was passed to facilitate the development of that. Now, the new developments which the legislation, the Act of Parliament had introduced, also received judicial acceptance or judicial imprimatur, particularly the concept of a separate legal entity or personality. And you might have heard of the case of Salomon and Salomon, because at our last meeting, no, not our last meeting, when we met physically in the classroom, I asked you to read that case, despite the fact that we had not reached there yet, but it was a very important case which you needed to read so as to have an appreciation of most of the things that we'll be discussing. So what happened in Salomon and Salomon? Well, in Salomon and Salomon, there was a gentleman called Mr. Salomon. He was a wealthy man in the beginning, but later on he became a pauper. Originally, he was a boot and shoe manufacturer and traded on his own as a sole proprietor or as a one-man business. And he used to call his business Solomon and Co. So that was how he called his business. And he had been in the trade as a sole proprietor for 30 years. And he lived in the same neighborhood all along for 30 years. And it got to a time when he became aware that there had been a possibility of registering your business so that the business will be seen as an entity on its own. Mr. Salomon decided to take advantage of it. And what did he do? Mr. Salomon actually got his business registered. He got the business he was doing as one man sold to this new company. And who were the members of this company? His wife and then his, 5 children. So the 5 children, his wife and himself, you meet the 7-member requirement, which is stated under the law. And he gave 1 share to each of them. And the rest of the share were actually his own shares, as it were. Then the amount of money which he had put on his business that he was selling to this company could not be paid. So he treated it as a debt which the company was owing him. So this was like the state of affairs. And then in the course of time, this new company, which he had incorporated to take over his business, was running business, and it also got into various debts with other creditors. And when the company practically collapsed and a liquidator was appointed to oversee the closing down of the company, various creditors of the company lined up, and Mr. Salomon also joined the queue and even sought to be ahead because as far as he was concerned, he was a secured even creditor of the company in respect of the amount of money the new company was owing him from the business that he sold to them. Now, the assets of this company were certainly not enough to be able to pay Mr. Salomon and all the other creditors. So some of the other creditors put up the argument through the liquidator that the claim that Mr. Salomon is making should actually be disregarded because he's trying to be fastidious, he's trying to shortchange everyone because as far as they are concerned, it was the same business he was doing for the past 30 years, which he had just registered as the new company at the same place doing the same thing with himself and the same people in charge. So his claim that the company was owing him as a person should be disregarded. Now, the courts went into it, and ultimately, as we read the full judgment, the High Court, the Court of Appeal, the House of Laws, the point to be made that despite the fact that in terms of reality, nothing had changed as far as the business the company was doing was concerned, insofar as it had been registered under the law, it definitely assumed the status of a separate legal entity or legal personality. And it was therefore different or separate from the incorporator, Mr. Salomon. And the fact that he incorporated it, or he was like the majority shareholder and all that, was not enough for his claim against the company to be disregarded. Please, this is just a bird's eye view of Salomon and Salomon. I would like every student to read the full judgment, okay? To read the full judgment. We'll come back to it again when we are discussing the theory of incorporation and piercing the veil. Okay, now still on historical evolution of the company law in Ghana, we have made the point that it is very much linked with the historical development of the company law in England and Wales, and we have seen how the story was in England and Wales. Now, what about Ghana itself? Well, in Ghana, the first companies legislation directly applicable to companies was the Companies Ordinance of 1907. And the Companies Ordinance of 1907 was essentially a reproduction of the consolidated legislation in England, 1862 Companies Act, which we have been talking about. But a major drawback of this 1907 companies legislation in Ghana was that it was essentially cut and paste, in the sense that we just copied the whole legislation which pertained in England and Wales under the 1862 one, and just reenacted it in Ghana. And the problem is that it did not reflect the peculiar situation in our country. So it didn't take our local circumstances into account, meaning that it was not fit for purpose in terms of our culture, in terms of political and economic situations in the Gold Coast at the time. And for that matter, when we had independence in 1957 and the Republican status, the government of Ghana set up a commission of inquiry. It was a one-member commission of inquiry. It was composed by Professor L.C. Gawa. Professor L.C. Gawa was a distinguished professor of company law from the University of London and all that. And his remit was to inquire into the working and administration of the company's ordinance in Ghana at the time. And based upon what he will discover, make recommendations for amendment and alteration of the company's ordinance. And he was particularly charged to look at what pertains in other parts of the world, especially in a way which will encourage African enterprise in Ghana, which will encourage foreign investment in Ghana. He did the work, and as yesterday we hinted at, that work resulted in a report, which we call the Gawa's report. And accompanying that report is a bill. And the bill, which was eventually reenacted as the company's code of 1963 at 179. And as we indicated yesterday, he provided a comprehensive commentary on each of the various clauses or provisions in that bill. But we also noted that since 2019, the Act 179, that is the 1963 legislation, has been repealed and replaced with Act 992. So I'd like you to, of course, if you have time, it's not mandatory, but if you are someone who wants to deepen your knowledge of how our law has evolved, you can just run your eyes through the old Act 179 and then the new Act 992 and identify some of the legal differences and similarities, just for your own academic edification. So let's explore some of the trajectories and inroads of the new Companies Act 2019, Act 992. Now, as we have noted not long ago, that the Companies Act 2019, Act 992, repealed and replaced the Companies Act 1963, or which we used to call the Companies Code 1963, Act 179. It is instructive to observe that this new legislation, Act 992, has introduced some novel provision, that is, it has made some innovations in our company law by making significant departure from some of the things which we had in at 179. We provide just few examples of that. So first of all, if you look at the new Companies Act, Act 992, it has abolished the need to file a constitution as part of the incorporation process. Now, previously, that is, if you look at the old Act 179, if you needed to register a company, you needed to submit a draft constitution known as regulations at the time. Under the new regime, it is absolutely possible for you to register a company without your own constitution, because there are default constitutions which will apply to you. It does not mean that you cannot have your own custom-made or tailor-fit constitution. You can do that, but it's not mandatory. Second, Act 992 has changed the use of regulation to constitution. So there has been a change in the legal language. So under 179, we used to say regulations. So regulation also replace the two documents which pertain under English law. In under English law, they have what they call Memorandum of Association and Articles of Association. Those of you who have done ACCA, you appreciate this point. But in Ghana, under the 1963 legislation, that is at 179, we abolish the concept of Memorandum of Association and Articles of Association and simply adopted regulation. Now, under the 2019 legislation, we've also abandoned the use of the word regulation, and we have now simply adopted constitution of the company. So let's keep that in mind. Again, the new legislation has abolished ultra vires doctrine in some way, and we'll discuss that. Another observable change is that under the new legislation, under Act 992, it provides surfaces to companies. And when we say surfaces, is the opposite of preface. So Mr., Doctor, Professor, Justice, whatever, they are all preface. Now, surface is the ending. So somebody will say Esquire, right? That is ending, and so on. Or GA, JSC, J, they're all surface. In the same way, when it comes to companies, we have now ABC Limited. You have LTD. Now, under the new law, when you see that, that should tell you that it is a private company limited by shares. Or if you see ABC, let's say that Ablikuma Mines PLC. If you see Ablikuma Mines PLC, the PLC simply means public company limited by shares. Now, previously, we did not have specific surfaces. We just had the simple surface of limited for all company limited by shares. But now we have various surfaces. Even if it's a company limited by guarantee, there's a specific surface for it. Another point worthy of note under the new law is that major transactions require authorization of shareholders. There's also creation of the Office of Registrar of Companies. Previously, we had simply Registrar General Department, and then the Registrar General Department was doing everything, including serving as a Registrar of Companies. But now, we have a standalone Office of Registrar of Companies. So let us keep that in mind. Again, well, there's a electronic or digital means of registration and communication and service. So a lot of things which previously will have to be sent by post and all that, they are done electronically. Now, if you want to know more about some of the specific changes which have been made, just copy the article, Revitalizing Gawa's Legacy, Performing Company Law in Ghana. And just copy and paste. Penn State International Law Review, I think an article that Taba did will come up, and then you can read more about that. So I'd like to take questions, if any, before we move on. If you want to speak, just put up your hand. Otherwise, we move on to another topic. So we finished the very general introductions.